Morning, folks.
Good morning. How are we doing, Lindsay, in terms of quorum?
I'm waiting on one more person. The 982 phone, is that a council member?
That might be Kelly Price.
Oh.
Yes, it is. I had to
Oh, okay,
fix something here. Thank you.
perfect, thank you. Then we're at quorum.
All right, good. Thank you. We'll call today's meeting of the Vermont Criminal Justice Council to order. And the first issue is any proposed additions or deletions to the agenda. Hearing none, I assume that we're okay with the agenda as circulated. Is Chris Lewis on today, or Lindsay?
Yes.
Yes. Okay. Then I want to propose a slight addition to the agenda to speak about a little bit about Chris Lewis. So with that change to the agenda, we will proceed to our first action item, which is the minutes of the November 1, 2020, that should be 2023 meeting. Is any suggested additions or deletions or changes to the November 1, 2023 meeting minutes as circulated? Hearing none, is there a motion to approve the minutes for that meeting as circulated?
Loris moves.
Chris Lewis moves. Is there a second to approve the minutes as circulated?
Anderson second.
Mark Anderson seconds. Any discussion on the motion? Hearing none, we'll call the question. All those in favor, please say aye or raise a hand.
Aye.
Any opposed to approving the minutes as circulated? The minutes of November 1 are approved. And Lindsay, we don't yet have minutes for December 19?
No, we will for the next meeting.
All right. Well, let me say one thing, that it's nice not to be in a hospital room for today's meeting.
It's nice
Oh,
to see you not in a hospital.
Thank you. Uh, So let me take up right now, Chris Luris, who is one, along with Brian Searles and myself, one of the three sort of gubernatorial appointees to the council who don't need to be recommended by anyone else. Chris has served us very ably during our first 3 years of the council, and for his own reasons has decided that he's not open to being reappointed for another up to 3-year term. I believe Chris's term, just like mine, I think expires sometime January 20 something, or am I wrong on that? And it's February something. In any event, what I'm not sure of is whether this is Chris's last scheduled meeting of the council before his departure from our ranks. And Chris has done excellent work for the council, most recently, particularly on the Act 50 report to the legislature on whether we suggest any revisions to the current statutory framework as it relates to professional misconduct on the part of Vermont law enforcement officers. So I just want to sincerely thank Chris for his contributions to the council, and on behalf of the council, wish him nothing but the best going forward. And Chris, I hope you'll be an active participant in today's meeting. Actually, I'm just seeing from Trevor Whipple that the official term expiration is February 29th, this being leap year. And so maybe we'll see Chris next month, but Chris, consider yourself recognized and thanked for your service, and we hope to see you at next month's meeting also.
Appreciate that. When I had sent my resignation letter to the fifth floor, it was under the assumption that January was when I turned into a pumpkin, or we turned into pumpkins. So I needed to make sure I came to this meeting, as it has a couple items on the action agenda. And if the fifth floor and the governor, who is my appointee, chooses not to accept my resignation till the end of February, then on next month will be my last meeting.
Great. I also thought my term ended December 31 and learned that I had 2 more months anyway. We'll see what the governor does, whether my tenure is extended. Excuse me. Next order of business on the agenda is our position of co-vice chair, ably held by Susanna Davis since we first elected the co-vice chairs. And Susanna served a couple of terms and agreed to stay on, but thought it was time for someone else to shoulder those responsibilities. We have Chief Frank as one of the co-vice chairs right now, essentially representing law enforcement. And I'm not sure whether Erin Jacobson volunteered or her arm has to be twisted to be a candidate for co-vice chair, but we appreciate her willingness to serve in that capacity. And I look for someone on the council, please, to make a nomination as to our vacant co-vice chair position.
I'm happy to make a nomination for Erin Jacobson to fill the very large shoes of Susanna Davis as a co-vice chair. of the council.
Thank you, Karen. Is there a
Jennifer
second
Frank
to Karen's
seconds.
motion?
Jennifer Frank.
Chief Frank, our other co-vice chair, seconds the motion. Any discussion on the motion? Hearing none, we'll call the question. All in favor of Aaron Jacobson being appointed, elected co-vice chair of the council, please raise a hand or say aye.
Aye.
Any opposed? Hearing none, Aaron, you're officially co-vice chair of the council, and if you want to say a few words to us, now would be a time, but you don't feel on the spot. You don't have to. You'll be an active participant in the meeting, I'm sure.
I am on the agenda for this meeting, so I hope to be an active participant, and I'm happy to serve as co-vice chair alongside Chief Frank and also you, Bill. It's an honor. Thank you all for your confidence in me. I do just want to say quickly, because I have the floor, thank you so much, Chris Loris. I happen to also be on the Act 56 committee these past few months, and that committee had some seriously good chemistry. It was a really, really great process, I thought, and that was under Chris's leadership. So gratitude to you too, Chris, for that.
Thanks much, Aaron, and you perhaps reminded me that, did I say Act 50 before when I was talking about the report as opposed to 56? If I did, my mistake. Next issue we have on the agenda is the fair and impartial policing policy review, and Amanda Garces is with us, I believe, and then Aaron will be assisting us with some input, and then we might well be hearing from Will Lambert from Migrant Justice. So Amanda, if you're the first one to go, the floor is yours.
Good morning, everybody. Thank you so much. For the record, my name is Amanda Lucia Garces. I am the Director of Policy, Education, and Outreach for the Vermont Human Rights Commission, and I serve as the co-chair of the Fair and Impartial Policing Committee subcommittee. So I am going to present. Just want to make sure that Migrant Justice has the right translation and everything's okay on that, Will? Okay, great. So I am just going to walk us through our process for the policy that you have received in your packet. And then I'm going to turn it over to Will, who will walk us through some of the decisions that were made and behind that. And then he'll turn it over to Aaron from the Attorney General's office that will speak about that part. So I'm going to share my screen just to show you you received 3 documents. Let me make sure are in the right thing. Yes. Sorry, I need to. Okay, so what I did for us was to ensure that we understood what we did in terms of the 2017 policy that has not been changed since then, and then what the committee has worked on. So in the report that you received, you will see the history behind this. There was a committee that was formed in 2019, I believe, what we call the ad hoc committee. That was representatives from my office, our former executive director, Bor Young, David Sher from the Attorney General's office then, a lot of members, Captain Storrell, who's now the vice chair here, Brickell, and many other members. So this has brought a wealth of expertise from a lot of offices in our state that came together. In 2021, they finished that report, and there was not really enough time to receive the input and the feedback that migrant justice community members were really requesting to be protected in our state. And the committee had kind of a deadline that they thought needed to be done by December 2021 or 22, so they didn't finish, and they turned it over to us. There was a little bit of a tumultuous period in that time of not understanding our charge as a subcommittee, but we came back strong and we decided to go over the whole document. we created another round of opportunities for migrant justice members to work with the Attorney General's office. I supported kind of that process for them to go over some of those recommendations, look at the policy that we had written, and then once that process was completed, they came back to us, and then the committee voted, which you saw all the decisions that have been made in that report. So what I did with this document was really try to walk you through some of the differences that were made between the 2017 policy and the recommendations that you see here today. So I hope you have time to really engage in that material. You might not need to do that, so that's why you have also just a clean policy. This green document just has the policies as is with all the recommendations. And then your third document is really your the report that gives the history that I just gave you, who was involved, how we got here, and then the last pieces is the conversation that Will from Migrant Justice and Aaron from the Attorney General's office will be discussing with you today, which has some of those disagreements that as a committee we had to kind of have the dialogue on. So I think that is my brief sharing of our process. I want to thank you all for your time, and I am going to turn it over to Will for the substance of this conversation. And then we can go back to questions for me, if that's okay.
Thank you very much, Amanda. Nice to see you. Good morning, members of the Criminal Justice Council. For the record, my name is Will Lambeck. I'm with the organization Migrant Justice. And before getting into remarks, I want to note we're doing this meeting bilingually, and thank you to Lindsay for, as always, helping to set up the logistics and administration of that. And for those who haven't been on a multilingual Zoom before, I'm just going to go over that very quickly. Those of you on a computer will see at the bottom menu row, there's a globe that says interpretation. In just a minute, somebody will be speaking in Spanish. And so if you would like to hear the simultaneous English interpretation provided by Abel Luna, who's on the line, please click English as your preferred channel. If you don't click English, you'll be hearing the remarks in Spanish. And then you can decide whether or not you'd like to mute the original audio or whether you'd like to hear the Spanish sort of at a low level behind the English translation track. So please take a minute to do that. If you are connecting on your cell phone, you can press the screen, press the 3 dots in the top right corner, and then you'll see the option to select English. I'll just give folks a second to do that. And then I'll turn it over to my colleague, Rosie Alfaro, to begin with some remarks, giving the context about why Migrant Justice as an organization and why the immigrant community in Vermont has taken such an interest in conversations around fair and impartial policing.
Okay.
Thank you, Rosie.
¿Me avisas, ok? ¿Ya? Ok. Hola a todos, mi nombre es Rosy Alfaro y soy parte de la comunidad migrante de aquí del estado de Vermont. Pues sí, vengo a representar a mi comunidad este día porque tristemente muchos de ellos no pudieron estar por el trabajo, aunque realmente es importante. Sí, y pues más que nada querer agradecer Sí, pues quiero agradecer el tiempo que nos están dando para que podamos tener esta reunión y podamos expresar lo que realmente necesitamos y es importante para nosotros. Ok, pues estamos aquí porque queremos que acepten el lenguaje que está recomendando el subcomité, porque realmente es muy importante para nosotros. Y es importante para nosotros porque ya no queremos vivir más con ese miedo con el que vivimos día a día. Queremos vivir tranquilos, queremos llevar una vida normal porque también tenemos derecho y también nos los merecemos. Estamos cansados de vivir con todo el tiempo con miedo y no llevar una vida tranquila. Yo soy madre de 3 hijos y todo el tiempo vivo con ese miedo. ¿En qué momento me van a separar de mi familia? Mi esposo y yo todo el tiempo estamos pensando qué es lo que debemos hacer, qué va a pasar con nuestros hijos, con nosotros. Quisiera que se pusieran en mi lugar, que se pusieran en mis zapatos por un momento para que sientan qué es lo que nosotros realmente sentimos, el pensar de que en qué momento nos pueden separar de nuestros hijos. Sí, es por eso que estamos pidiendo que acepten el lenguaje que el subcomité está recomendando, porque para nosotros es realmente importante. La comunidad en Vermont está creciendo. Ahora hay muchos trabajadores en la industria lechera, en construcción, en restaurante, en limpieza y en muchos trabajos más. Muchos de la comunidad viven con ese miedo, no solo yo, no solo mi esposo, sino que muchos de la comunidad vivimos con ese miedo de en qué momento nos pueden, de en qué momento puede la policía pararnos y ser deportados. Nunca podemos tener esa confianza como llamar a la policía cuando algo está sucediendo, cuando un problema tenemos, cuando algún accidente tenemos o algo realmente peligroso está pasando con nosotros. Nos quedamos callados y de brazos cruzados por el miedo de que no podemos contar con la policía, no podemos tener esa confianza de poder estar en contacto con ellos. Muchos de nosotros hemos tenido grandes experiencias sobre eso. En mi persona he tenido grandes experiencias como he tenido accidentes, he tenido problemas y me he quedado de brazos cruzados. Me he callado por lo mismo, por el miedo de que me puedan alejar de mi familia. Creo que eso es injusto. Necesitamos una vida normal, queremos vivir tranquilos. No soy la única persona. Tenemos ejemplos como mis compañeros de ranchos. Hay personas que hace 7 años no han salido ni siquiera a la tienda a comprar por ese miedo, porque tienen miedo, porque no salen, no pueden salir confiadamente que pueden hacer las cosas. Yo pienso que eso es inhumano y queremos una vida normal. Y pues por eso estamos pidiendo que puedan aceptar nuestro lenguaje, la implementación de la política, porque hemos tenido muchas experiencias, hemos visto muchas experiencias como compas han sido arrestados por que la policía ha colaborado con migración. Y pues tenemos grandes experiencias en todo eso, y por eso es de que todo el tiempo estamos con miedos. Tenemos un ejemplo grande con el sheriff de Essex, que él dijo que se sintió muy confiado, muy cómodo en la prensa, diciendo que gracias a él han arrestado más de 20 personas porque él ha colaborado con migración. Y pues no sabemos si es el único que está colaborando con migración, y por eso es realmente importante que se cierren esos huecos, que ya no haya más colaboración con migración, porque queremos llevar una vida más tranquila. Aquí en Vermont hay 9 pueblos que ahora tienen nuestra política, que esos pueblos se comprometen a adoptar nuestra política, no colaborar con migración. Queremos más así, queremos que todos sean así. Nosotros pues realmente lo necesitamos, no queremos estar todo el tiempo con ese temor. Y pues no soy la única persona, toda la comunidad vive con eso. Yo creo que tenemos derechos y necesitamos como llevar una vida más tranquila.
Thank you very much, Rosie. Thank you, Val, for your interpreting. I'll add a couple points to that before turning it over to Aaron. Since 2012, Migrant Justice has been engaging with various bodies in the state of Vermont around what originally was called bias-free policing, and of course now is fair and impartial policing, in order to ensure that these policies and practices in Vermont include strong protections for immigrant communities in the state, particularly to limit the collaboration between local and state law enforcement on the one hand and federal deportation agencies on the other, with the simple premise that Vermont police should not be in the business of deportations. Since 2017, we have worked diligently to try to close the loopholes that were placed into the policy to respond to the Trump administration's threats against so-called sanctuary cities and sanctuary states, threats that were backed up by then Jeff Sessions' Department of Justice's threat to cut funding from certain jurisdictions. These Trump-era loopholes have done incredible harm to the immigrant community in Vermont and to the relationship between immigrants and law enforcement in the state. And under these loopholes, which remain in place throughout the state, many immigrants have been discriminated against and turned over to federal deportation agencies, separated from their families and their abilities to make a living. Over the past 2 years, we have worked very closely within the Fair and Impartial Policing Subcommittee and in particular in conversations with the Attorney General's office in an attempt to close these loopholes and strengthen the policy. And we are very proud that the Fair and Impartial Policing Subcommittee has recommended changes to strengthen the state's model policy. And you have those recommendations in the report provided by Amanda. In most of these instances, we have been able to achieve compromise and consensus with all parties and the subcommittee and with the Attorney General's office. But in 2 instances, we differed in our final analysis from the Attorney General's office. And as you see in the report, while the majority of the subcommittee supported strengthening the policy as envisioned by Migrant Justice, there was not full consensus on some of those matters. And you'll hear in a minute from Aaron as to why there is a competing proposal from the Attorney General's office. Briefly, there are 2 issues at hand. One is, how does the policy intersect with federal policy? And in particular, these statutes with which many of us are familiar at this point, 8 U.S.C. 1373 and 8 U.S.C. 1644, which place restrictions on limitations of certain types of communication with federal immigration authorities. The suggestions from the Fair and Impartial Policing Subcommittee reflect policy language that has been adopted in 9 jurisdictions around the state. 8 municipalities, among them the largest police departments in the state, and 1 county sheriff's office. What's called the Winooski model, because the Winooski Police Department were the first to introduce this language, has a very simple statement. Nothing in the Fair and Impartial Policing policy is intended to violate federal law. This is the recommended language from the Fair and Impartial Policing Subcommittee. You see alternative language in the Attorney General's office proposal, which goes into much more detail, trying to provide specific guidance to law enforcement about how to interact with these federal statutes, which I'll refer to by the shorthand of just 1373. The legal issues on this are complex, but the core of the matter is that this is contested legal terrain. There were many lawsuits in 2017 and 2018 as the Trump administration sought to deny funding of certain Department of Justice grants to certain jurisdictions. In the vast majority of those lawsuits, the court sided with the jurisdictions that were limiting collaboration with federal deportation agencies, writing that these federal statutes are unconstitutional on their face. As you will hear from Aaron, not all courts ruled that way. And in particular, the Second Circuit Court of Appeals sided with the Trump administration at the time. However, while the case law at the federal level remains contested, it's important to recognize that what brought about these lawsuits was a Department of Justice policy which is no longer in effect. The current Department of Justice has made very clear that they are not looking to any departments to certify compliance with these federal statutes in order to grant federal funding. And in fact, the 9 jurisdictions around the state which have implemented the language currently being recommended by the Fair and Impartial Policing Subcommittee have faced no repercussions. There have been no lawsuits. There have been no contested labor matters on the enforcement of this policy. They have been able to implement this policy with the streamlined language saying nothing is intended to violate federal law, with no negative repercussions. And we think what has worked in those 9 jurisdictions can work in the state level as well. And we can get more into the details of this once you hear from Aaron as well, and we're happy to answer more questions on that. But that is the first matter, how to deal with language regarding federal policy. And the second and final one that I'll talk about, where there's not full consensus coming out of the subcommittee, is about what we would call the standard for permissible communication between local law enforcement and federal immigration agencies. Now, this is an issue that isn't directly related to 1373 because that federal statute doesn't apply to all communication between local law enforcement and the feds. It only applies to certain types of communication related to an individual's citizenship or immigration status. So the policy can and does have a standard for when communication is permissible that is unrelated to the federal legal questions of 1373. And what you have before you are two different standards. There is a stronger standard which limits communication to certain circumstances. And as you can read, it's circumstances when such communication is necessary to the ongoing investigation of a felony for which there's probable cause and the investigation is unrelated to the enforcement of federal civil immigration law, or with the consent of the individual when it would benefit them in a visa application. So the Fair and Impartial Policing Subcommittee and the 9 jurisdictions that have adopted this language recognize that there are some instances in which communication is appropriate. But those instances should be extremely limited, and there should be a high standard for determining when such communication can happen in order to ensure this principle that Vermont police are not in the business of deportations. You have an alternative proposal from the Attorney General's office, which makes some tweaks to the current 2017 model policy that's in place, but generally maintains the same structure. And that's communication is permissible when it's necessary for public safety, officer safety, or law enforcement needs unrelated to the enforcement of federal civil immigration law. We see that over the past 6 or 7 years, these standards have allowed for continued collaboration between local law enforcement and federal deportation agencies in a way that has been very deleterious to the well-being of immigrants in Vermont and to the relationship between immigrants and law enforcement in the state. These standards are overly broad, and we have seen through documented evidence that officers have looked to them to create pretexts in order to justify their participation. Oftentimes, we are only made aware of these actions because of public records requests after the fact and the existence of body cam footage. And you heard Rosie speak about recent reporting from the Times Argus, which was very concerning to many immigrants around the state, as well as others, where a sheriff in Vermont said that over the past year, he estimates that he's referred approximately 20 cases to federal immigration authorities. And he said, quote, that he would likely call immigration authorities after a traffic stop if he thought the people in the car were undocumented. It is shocking that in 2024, there are law enforcement officials in the state who are admitting this publicly, that they would likely call immigration authorities if they suspect somebody is undocumented. And this state of affairs has been permitted because of the continued existence of the Trump-era loopholes in the fair and impartial policing policy. And that's why we believe it is so important that the Criminal Justice Council accept the recommendations of your own Fair and Impartial Policing Subcommittee, follow the lead of Winooski and jurisdictions around the state who have taken out these Trump-era loopholes and strengthened the fair and impartial policing policy to ensure that we are meeting our goal of ensuring that Vermont police are not in the business of deportations. Thank you very much.
Thank you. Aaron, I think the floor is yours.
Great, thank you. Thank you, Will and Amanda, and thank you, migrant justice folks and community folks for being here. I just want to acknowledge at the outset that, you know, when I hear feedback from our migrant community members, like how you live in fear, you fear deportation, you fear the police, you fear calling the police for help. I hear you, and I'm sorry that that is your reality. I take that to heart. And in terms of the Attorney General Office's proposal here, it reflects the reality of federal law and how federal law constrains what the Attorney General's office can propose here, and then if adopted, would defend. If the proposal as presented to the council by the FIP subcommittee were adopted, then it's the Attorney General's opinion that would be a really difficult policy to defend, because it is our opinion that it conflicts with federal law. And because it conflicts with federal law, that then implicates two provisions in state law. And those provisions are at 20 VSA, 2366F, and 20 VSA 4651D. They both say the same thing, which is that the FIP policy requirements are not intended to prohibit or impede any public agency from complying with the lawful requirements of 8 USC 1373 and 1644. To the extent that any state or local law enforcement policy or practice conflicts with the lawful requirements of 8 USC 1373 and 1644, that policy or practice is, to the extent of the conflict, abolished. And so from the Attorney General's perspective, whose job it is to be the lawyer for the state of Vermont, our concern is that with the proposal put forth to you by the FIP subcommittee, that it would conflict with federal law and therefore would automatically be abolished by the construction of our state laws. So because our state laws say any conflict with federal law, therefore would then abolish the policy, that is what we are trying to avoid here. And so in the work that my office did in conjunction with Migrant Justice and the ACLU and Amanda helping us along, we really tried to push the FIP policy as far as we could to be as protective as possible as we thought we could. And by protective, I mean of our non-citizen Vermont community members without violating federal law. And as Amanda indicated and the FIP subcommittee indicated in its report to you all, that is where Migrant Justice and our office agreed on 3 of the 5 proposals. And I really appreciate that we were able to come to that agreement, because we worked hard to get there. And we do think we strengthened the FIP policy because of that work, and we were all in agreement. It's with these last 2 proposals that are on, begin on page 5 of the FIP subcommittee's report, where we diverged. And Will did a fantastic job of just explaining that divergence and what Migrant Justice's proposal is. It's the Attorney General's proposal that you do see on beginning on page 5, that we think both complies with federal law and provides clarity for law enforcement. And not just clarity for law enforcement, but also clarity for the folks who would be training law enforcement. And that was something that Julio Thompson at my office was working on with me. We talked a lot about how do we propose something that isn't going to, create an overly wordy, lengthy policy, but still provides clarity for those law enforcement officers who need to then go out into the field and follow and implement the policy. So we did, there was a balance there. We certainly added a fair number of words to the policy, but we think that what we added helps make for a more implementable, easier to understand policy while still complying with that federal law that states that no state can mandate that their state and local law enforcement officers may not communicate citizenship or immigration information to the feds. So the state of Vermont cannot, by federal law, create a policy that tells law enforcement you cannot communicate citizenship and immigration information to federal immigration enforcement. And that is the part of the federal law that Will was talking about has been litigated. Some jurisdictions across the country, some circuit courts have said, oh, well, we think 1373, we think that law is unconstitutional. Unfortunately, in the Second Circuit where we all reside and the Second Circuit law that we all follow, the Second Circuit has said, no, we do not think that is unconstitutional. That has been litigated all the way up to parties asking for the Supreme Court to consider the question. The Supreme Court of the United States has declined to consider the question. Now, if you go back to my point about the Attorney General's office being the lawyer for the state of Vermont, we have to weigh what would happen here if there is a policy on our books that under current law would be considered unlawful. We would have to litigate that all the way up to the Supreme Court. We would lose at the Second Circuit. We know this because of Second Circuit case law on the books now. If it went to the Supreme Court, then we'd have to consider what the composition of that court looks like. As you all probably know, not favorable on the immigration front. So these are the considerations that the state of Vermont's lawyer is considering when putting forth a policy before the council. I wish the federal law looked different. It does not. It's constraining in terms of what we think we can suggest for a policy that complies with federal law and that we think that our training council can train to and that our law enforcement officers can implement in the field. I'm happy to take any kinds of specific questions, but I did just want to explain where we're coming from in our proposal.
So Aaron, how many, if you know, how many other circuits agree with, well, let me first of all say to the members of the council, Vermont is in the so-called Second Circuit Court of Appeals. So one of the jurisdictions where, unless and until the Supreme Court rules otherwise, the law or the rule in our circuit is set by the Second Circuit Court of Appeals, which sits in New York City. Roughly, Aaron, what's the split between the federal circuits on this issue? Is the Second Circuit in the minority or the majority of circuits that have ruled, if you know?
I don't know off the top of my head. I know some circuits haven't contended with this question, and I think it might be 3 circuits who've said that 1373 is unconstitutional. Will, do you know the answer?
I believe it's 3 as well. I'll put it in the chat in just a second.
Thank you.
And there's been an application to the Supreme Court for the Supreme Court to take up the matter, and typically the Supreme Court looks to situations where there is a so-called split of authority within the various circuit courts and feels the need and the obligation to try to resolve that so that there's a uniform interpretation of the law across the full country as opposed to a circuit by circuit issue. And has the Supreme Court given any guidance as to why it has denied cert in this matter, in which clearly there's a split between various of the federal circuits?
I do not believe so. I could add a little bit of information to the procedural pathway that the request for the Supreme Court to hear the case took. So in the Second Circuit, where we sit, the question about 1373's constitutionality was raised. A 3-judge panel of the Second Circuit said, no, we do not think that 1373 is unconstitutional. We already have a case on this. We already said it was constitutional on its face. We're not going to take this up again. Well, that decision for the Second Circuit to not take it up again before was challenged. And so what that looks like is a litigant would say, okay, well, 3 of you judges said you don't think you think this law is constitutional. We would like a full panel hearing on this, which is, I don't know how many judges, maybe you do, Bill, or anyone else in this room. But it's several more judges. So it's a full panel review is what was requested. The Second Circuit denied that full panel review. And it was that decision that was appealed to the Supreme Court. So then the litigant, the party litigating this said, actually, we think that the Second Circuit should provide a full panel review. What do you think, Supreme Court? And the Supreme Court said, yeah, we're not going to answer that question. So
Okay.
it wasn't the appeal to the Supreme Court of the state of the United States was not on the merits of the constitutionality of 1373. It was just on the seeking of the full panel review.
I understand. We're sort of in the weeds now.
Yes, sorry.
between-
Well,
No, that's my question that led us there. So, but now I understand. The Second Circuit, the 3-judge panel ruled that this provision was violative, and the full Second Circuit has declined to take up the matter, essentially deferring, at least thus far, to the decision of the 3-judge panel.
the 3-judge panel held that 8 USC 1373 is constitutional.
Yes, I'm sorry, I
Yes,
misspoke on
yes,
that.
Yes,
So the state of the law in our circuit, which includes Vermont and New York, is that the federal provision in question is constitutional and should be enforced.
correct. And some other circuits, we think maybe 3, have held that 8 USC 1373 is unconstitutional.
Understand.
Yes.
So do either Aaron or Will or Amanda want to just, for the sake of the council, help us understand, is it basically now just a situation between the AG's office is saying that 2 of the 5 issues that were contested remain outstanding? In other words, the AG's office has not agreed with Migrant Justice on the 4th and 5th, or 2 of the provisions, and your office is suggesting that that the AG's office, given its reading of current law, would not defend a policy that we enacted that, in your view, was violative of the current state of federal law in our jurisdiction.
So I have 2 responses, because that was kind of a 2-part question. One is, it's not an outstanding question for the FIP subcommittee. The FIP subcommittee voted to approve all of the 5 migrant justice proposals, 3 of which we agreed with. There's 2 that we did not agree with, and our proposal is reflected in the FIP subcommittee's report. And then about whether or not the Attorney General's office would defend the policy as recommended to you by the FIP subcommittee. Of course, we would try our hardest. That's our job. It's just that we have to provide our best legal opinion as the lawyer for the state of Vermont, that first of all, the proposal before you from the subcommittee, we think under state law could mean that some of the provisions of the FIP policy are just voided. Secondly, if we were to defend this policy in the courts, in this jurisdiction, which is Vermont, in the Second Circuit, we think we would lose. And so then the policy also could not be implemented.
So I guess I misheard you earlier. The AG's office is saying it would be uphill sledding to successfully defend the full proposed FIP policy if there was litigation, but you're not saying you wouldn't try your hardest to uphold it, but you think, given that we are in the Second Circuit Court of Appeals, we would likely lose that battle.
That is correct. And I would also say, to add to all of that, that if a law enforcement officer violated one of the provisions of the FIP policy that that we don't agree with, if the subcommittee's proposal is adopted by the council, and then a law enforcement officer violates that policy, then it is our opinion that it is possible that state of Vermont law could abolish the policy that the law enforcement officer was just accused of violating. And so then that law enforcement officer their argument for why they shouldn't be sanctioned by the council would say, well, you can't violate an unlawful policy. So that would be their defense to council sanctions. And so in that way, the question is like, how is this an operable policy? How can it be enforced if the officer could make a very valid legal argument that it's an unlawful policy? So that's another concern that we would have.
All right, thank you. And Will, do you have something more to offer?
Yeah, thank you very much, Bill. And yeah, thank you, Aaron. I think you lay out really clearly, and throughout this process, we've had tremendous respect for the way that the Attorney General's office and Aaron has approached the matter, and we believe that what they're presenting, those are based on honest convictions and well-reasoned belief. But we do have some disagreements in the analysis. We agree with Aaron that it's unfortunate. It's very unfortunate that the Second Circuit declined to rule 1373 as unconstitutional when they had the opportunity. And that puts them out of step with the vast majority of courts around the country. And because of the issue that federal funding is no longer at stake in these distinctions, the issue is not going to be resolved by the Supreme Court in the foreseeable future. Because the sort of standing that brought about these lawsuits in the first place are no longer present for jurisdictions. But we would argue that the state law that Aaron cited is crafted very specifically, and it includes the phrase, the lawful provisions. It includes that phrase 2 times. We believe it could be the position of the Vermont Criminal Justice Council that there are no lawful provisions of 1373 because it's a violation of the 10th Amendment and the anti-commandeering principle. And that's the analysis that most courts in the country have taken. That analysis would put the state of Vermont out of sync with the Second Circuit. And Aaron is correct that there is a hypothetical situation through which there's litigation that would go up to the Second Circuit and perhaps the Supreme Court. And that would be an uphill battle. We don't debate that. But we would say that we don't have to rely on hypotheticals. We can instead look to the facts on the ground throughout the state of Vermont over the past 6 years. And those facts are that the city of Winooski the city of Burlington, South Burlington, Richmond, Shelburne, Hartford, Brattleboro, Norwich, and the Addison County Sheriff's Office have all adopted the policy that the Fair and Impartial Policing Subcommittee is recommending to you today. In those 9 jurisdictions, there has been uniform compliance with the policy as written. It has not been challenged based on its accordance with state statute. It has not been challenged based on its compliance with federal statute. Officers in those departments and agencies have been given clear guidance saying, in the majority of circumstances, don't pick up the phone and call ICE. Don't call Border Patrol. Don't share information, except in very limited circumstances. And they have followed those clear instructions that they've received. The policies have been implemented without incident, and the jurisdictions haven't been opened up to litigation. It hasn't happened in 6 years that those policies have been on the books. So yes, there is a hypothetical scenario where we're battling in front of the Supreme Court and nobody knows how that would end, but we don't need to go there. We can look at what's happened in Vermont over these past 6 years.
Thank you. I believe Chief Frank, on behalf of the Chiefs Association, has raised some issues about this matter. And Chief Frank, am I correct?
Yes, I'm going to bring forward, there were 15 summary concerns that came from the Vermont Association of Chiefs of Police. At the outset, we just want to make sure, given the recent discussion, that we need to address the law as it stands now. Under the Second Circuit Court, until they amend that position, we can't in good conscience ask our officers to knowingly violate federal law. And quite frankly, knowing that we don't have a position, we would have a lack of defensible representation from our officers. That's a pretty significant concern. There are 15 specific concerns that were brought up. I don't want to go through each of them piece by piece, but I did outline the 15 elements of those. Most of the concerns surrounded some federal communication issues, recognizing that especially our northern border chiefs work very closely with Border Patrol and other federal officials. Those are their backup officers. They're the closest officers who can provide support, whether it be the execution of search warrants to responding to and assist on a motor vehicle incident. And so there was some concern regarding the lack of communication and how that would impact some of those relationships. There was some specific elements regarding stripping conversations that were more position related, but as we go through those are less about the policy and more about the comments that initiated the policy. And so I think there was some confusion there among some of the folks that responded between here's the actual fair and impartial policing policy and here's what led to the discussion that created that. Because I'm a representative of the organization, I brought all those forward for folks to see, but some of those are a little less relevant. There was also a major concern that 2 policies were kind of becoming merged together that perhaps should be separated. One was more a fair and impartial policing policy, and others felt this was an immigration policy, and that we should really separate the two, that there should be a fair and impartial policing policy, and then if we want to examine immigration policy, that can be done differently and separately, but that we are instituting an immigration policy in more of a bias-free discussion through that element. Some of the other concerns were more specific to requiring passengers to provide information or not, and I believe those were just wordsmithing. But again, the general sentiment is that as chiefs in general, we don't feel that we can be in a position where we're going to ask our officers to knowingly violate federal law, and that's even more reinforced with a feeling or a belief that we would lack defendable representation. The other concern is that because this would become a statewide policy, any violation or variance from that would automatically make any officer subject to an Act 56 professional regulation potential review and examination that could cost an officer their certification.
So I don't want to put words in your mouth, but if we put this matter to a vote between the Fair and Impartial Policing Subcommittee's recommendations with all 5 of the points in conflict, if you will, there in the proposed policy, as opposed to what the AGO was at least saying, that there are these two outstanding issues that remain, in their view, problematic. Would the Chiefs Association likely be a no vote if the proposal was to do all 5 of the points in contention in line with the committee's recommendation?
That's correct. As it stands, the Vermont Chiefs cannot support it in its current focus. We want to be very clear, though, that that doesn't represent an ideology that doesn't support fair and impartial policing and recognizing the identification of bias and not including that in our enforcement. So from an ideological standpoint, we want to be clear. We support conceptually, but as it stands right now, the Vermont Chiefs cannot support this moving forward.
All right. And Amanda, do you have more to offer us that you'd like to chime in with right now?
Sure. I would just some closing comments about some of the chief's concerns around the immigration versus fair and impartial policing. And I just want to kind of disagree that when we look at our immigrant communities, we cannot look them separate from like whether they're documented or undocumented. They are an integral part of our community. And when community members walked down the street, they cannot hide who they are, right? That is what fair and impartial policing is like being able to be fair, whether your race, your language, yourself is different from the Vermont that a lot of people know. So I think it's really important that yes, there is heavy conversations around the immigration status because we have seen historically what has happened to our community members here. And that is really an integral part of this policy. The fair and impartial policing as it is, the current policy was drafted by also a lot of BIPOC community members, Black advocates that have come together really to push our state to do better because we weren't doing good. So this is an opportunity for us to really have that moral ground and moral high, you know, one day after Martin Luther King Jr. anniversary, that we really have to think through this about like how we're going to support, how we're going to live in Vermont and support our community members who are giving so much of themselves to us, and what you committee and the Criminal Justice Council can do to support that community. So that's what I wanted to say.
Thank you. I think I saw a communication from Karen Tronsgaard Scott earlier in the meeting saying that she was going to have to leave the meeting, but at the same time she had a number of thoughts about this issue. I might be mistaken on that.
No, you're correct.
Okay. All right. Here's my inclination. We had this here as an action item. I'm not sure I could ask Lindsay, but I don't think it would change my thinking. We barely got a quorum today. We were waiting to get the one more to put us over the top. This conversation today has been very helpful to me, and I'm assuming to other council members. My inclination is, and I'm happy to hear from other council members at this juncture, but to put off a vote until our next monthly meeting, our February monthly meeting, and not just to let this float indefinitely into the future. We are unlikely to have a consensus on whatever our vote is, and that's fine, that's healthy. So please accept my commitment that this matter will be on the agenda at our February meeting and that we will take a vote at that time. If there are council members who disagree with that thinking or wish to right now state their own personal or the organization they represent's feelings, we can hear from any council member on that right now. But otherwise, my thought is that we can have further discussion a month from now and take a vote, however the vote goes. I see a hand up, I think.
You do, it's mine.
Oh, all right. Susanna, thank you.
Hi, thank you. I just wanted to say, I agree with putting this for the next agenda, not and I want to say why I agree. It is very troubling to me that this has been called for years now in the state, because it carries real life and death consequences for people. And so, you know, a part of me is very saddened and frustrated at the sense of delay and waiting and holding one's breath forever. And yet there's so much thought and work and nuance that went into this proposal. We're getting a lot of information really quickly as a council. I was part of that subgroup, so I understand what we're talking about and why this word is shall, not may. But I want to make sure that the full council really understands the nuance, particularly in light of some of the comments that we received from the Chiefs Association. And so I would agree to putting this for the next meeting, but with a huge asterisk that I implore my fellow council members to come really prepared, having looked it over deeply, having considered it, because I really need us all to be coming from an informed perspective when we look at it and when we vote, because this is it's too important. And so I guess what I'm saying is +1 to the suggestion of delay, but not so that we can all just chill for the next month. Let's really individually work hard to understand what it is that we're going to come back and look at next time. Please, thanks.
I agree with you 100%, Susanna. Thank you. Any other council member want to be heard on this matter right now? Trevor Whipple.
And thank you. And I too agree. This was a lot of information that we got on Friday to really piece together. And it's important. It's important to all members of our community. We at VLCT would really appreciate the added time to do a bit of a legal review. And I would ask my other council members to consult with whoever your legal counsel is. You know, one of the potential concerns, and we're not sure yet, is that if there were litigation because something in this policy was found to be a violation of federal law, there may not be insurance coverage for that. It may be an exemption, and the community itself would bear that. So we know it's a fine line, and we want to do everything we can to support all members of our community, but also to support you know, everybody in the community. So it's a huge task. It's I understand the importance of it, and really do appreciate the added time to really dig in and digest the very specific, as Susanna points out, sometimes it's even a word. So this is very helpful. Thank you.
Thank you. Other council members who wish to be heard on the issue today that we've been discussing?
I would like to add something as well. The Human Rights Commission will support the full recommendation from the subcommittee. So I wanted to share that information, and I'm happy to discuss that further with individuals or at the appropriate time. I have no objection to allowing people to digest the large amount of information, with the caveat that, as people have mentioned, that it actually will be up for a vote and will be considered, as people have been waiting an extended period of time, and the people who this impacts the most are waiting for us to take action. So thank you.
Thank you, Cassie. Jim Wickham?
Thank you, Chair. Yeah, just out of the interest of process, one of the comments that came up in the short amount of time that we had all this information from Department of Public Safety is the ability to review the policy in a traditional track change way. I know a lot of work has been done to try to separate out and give those changes in a separated version of track change. But out of interest of process and looking at words and that words matter, that traditional view, crossouts with underlines and additions is a helpful model for us. Thank you.
I agree with that. I like to see the side by side, or so it's clear to me what's coming in and what's going out. Amanda, I see you have your hand up.
Yeah, I just want to offer that it's because there are a lot of changes that you couldn't do track changes because there's a lot of change. This is why I created that side-by-side document with the 2 columns. The left-hand side is what explains the 2017 policy and what was changed. There are some entire paragraphs that are new that you can just track change. It will be really difficult. When we absorbed this work from the committee, they couldn't even do the track changes either. So I spent a lot of time doing that 2-column document, which is not perfect, but it kind of gives you a sense of what is different from the 2017 policy. It really is not possible to do a track change in what we are giving you. So, I mean, it could be, but I think it will be too full and brains won't be able to take that. I tried, trust me.
Other hands up on behalf of the council? And Lindsay, let me ask you that you recirculate the documents at least 2 weeks before the next time the council will be taking this up, and making clear that we will be taking a vote of the council at that next meeting, and folks should pay attention, consult legal counsel if they need or wish, and make sure their supervisors are apprised of the issue, and see where things come out when we take a vote roughly a month from now.
Absolutely.
All right. Thank you. Thank you for that. And I learned a lot, and to the extent that the delay in our taking this matter up again, I never made an affirmative decision. Oh no, let's not bring that up. It's too contentious. It didn't happen. It's just, but to the extent that I'm responsible at all for the delay in bringing up this matter, my apologies. And let's move on to level 3 curriculum topics. And I think Ken Hawkins is with us to talk to us about that issue.
Good morning, sir. Good morning, members of the council. Thank you for being here. Thank you for all the work. This is the annual. If Lindsay could put up the presentation.
Yes, give me just 1 second.
If I do it, I will break the internet. So she's kind enough to put that up for us. But this is the annual review for Council Rule 9 for members of the council to vote on the minimum number of hours allotted for each of the topics for the basic training course.
Creo que sí.
Level 3.
Pues no sé, Will está aquí, pero no sé si se salió. Creo que sí. Nos salimos nosotros, ¿verdad?
We're hearing Spanish also. I haven't changed my setting just to have English, so.
Sí, a ver.
Sure.
Hay que salir.
Okay. So this is the minimum number of hours for each major topic for the basic training course, and needs to be specified by the executive director and approved by the council, as long as it consists of a minimum number of hours of training to not be less than 792 hours per training course. And again, this is the level 3 17-week basic program. So at the beginning of each year, we ask the council to review that. Next slide. So the curriculum summary essentially consists of disciplines of law, investigative procedure, professional demeanor, physical fitness, control techniques, and administrative time. Right now, our current is 832 and a half hours that we include in that 17-week process. Next slide. To drill down a little bit in each of those under communications, we go through courtroom demeanor, media and public relations, report writing, de-escalation. Next. Within the law, somewhat. Within the law category, we go over criminal law, motor vehicle law, hazmat, VCJC, alcohol services administration, introduction to federal agencies, juvenile law and procedure, liability, sexual harassment, landlord and tenant law, use of Vermont statutes, crash investigation, evidence collection, CSI, death investigation, and death response, domestic violence response, drug ID, interview and interrogation techniques, sexual assault investigation, sexual and physical abuse of children, strangulation, hate crimes, VCIC certification, which is actually done online, victims assistance program, vulnerable adult abuse, stalking, basic fingerprint techniques. This is certification, animal welfare investigation, traffic incident management systems, also known as TIMS. On professional demeanor, we go through core values, leadership training, foundations in legitimacy in policing, death notification, police ethics, community policing, officer wellness, fair and impartial policing. Physical fitness is roughly 114 hours, to include health, wellness, and physical fitness all in one category. Control techniques is probably the largest block, to include patrol procedures classroom, emergency vehicle operations course, mental health crisis response, interacting with deaf and hard of hearing, interacting with people with physical disabilities, the practical scenarios, the final scenarios, which are the graded evolution. Active shooter response has now been moved to post-basic. It's actually a certification level now that we're doing in conjunction with Vermont State Police. The firearms training, use of force and tactics, search and rescue, OC certification, first aid, CPR, along with casualty care as part of that. First aid, CPR, VIN certification, mandatory reporting, DUI and DRE enforcement, and FEMA 100, 200, and 700, which are all being completed online. Additional time, administrative staff time, drill and ceremony, all the things we do to prepare for the eventual graduation of the course, and the final exam. So that's the broad overview. There has been little change since we approved this last year. The only, I think I spoke to it earlier, the major change that we've done was to move the active shooter training to a certification level, as opposed to the 4 hours that we would do during patrol procedures with the class around the midterm scenario time. That's my presentation, sir, and I'm happy to answer any questions.
I have a question, and maybe the question is more for Heather or for Chris McKell, but let me remind the council members, we're in the first year of a 3-year initiative where we sought, I believe it's $1.4 million over 3 years from the legislature. First year funding, $200,000. We received that one-time funding, and we're now asking for the second year appropriation from the legislative session that just commenced. But the idea being that during this first year of the 3-year initiative, we will be taking a comprehensive look at the existing curriculum, and with the help of IATLIST, contract with them for their expertise and input from law enforcement and any number of other sources, that we will propose changes to the curriculum. under the statute that creates the council, where to look more into alternatives to the 16-week basic training curriculum to perhaps accommodate those single parents who wish to come into law enforcement, to see about cooperative ventures with higher ed and the state, perhaps for some aspects of law enforcement training. I could go on, but the idea is that we take a fresh look at what we're doing, make the revisions that we believe would be called for, and implement those roughly in the curriculum for the second year of the 3 years, and then be analyzing what we got right, what we got wrong, and tweak the second year curriculum during the third year. And so my question for you, Ken, sorry for being long-winded, is how, if at all, does our vote today approving what you're putting in front of us impact the fact that during the next 12 months, we might well be implementing some perhaps significant curriculum changes?
So I think, and Heather would probably be better to speak to the timeline. I think she's more aware of that than I am. Right now, I am aware that the job task analysis and the preparation of the outreach to agencies, officers, agency heads is underway. That will speak to a portion of that curriculum development and what that'll look like. Today's vote is really just to speak to the next 12 months of training that we will provide to our level 3 officers coming through, recognizing that, as you said, that we need to be Sumper Gumby, and recognizing that change is underway, and that as soon as that recommendation from my analyst comes through, I'm sure that's going to be a presentation that the executive director will make to the council.
And so my assumption is that if we want to make changes in terms of the hours or the mix of the curriculum, the situs of the training and such, that as long as it's approved by the council, it would be deemed, to the extent that it's at all different from the action item that's in front of us today, that the action of the council would be legitimately effect changes to what we're approving today, assuming we approve what you're requesting.
That's my understanding, sir. Again, I would
And I won't ask Kim McManus to say how wrong the chair is, but we will assume right now that what I said is accurate. Questions for Ken Hawkins about the proposal, which is on our agenda for as an action item?
Hey, Ken. Kelly Price. Quick question for you. What are the major changes in what you just presented from past practice, the main changes, if any? That was the first question. Second question is, moving forward, let's say this next pot of money comes, however you want to look at it, what would you like to see in the future moving forward in additions to what you just presented?
Thanks, Kelly. Good to see you. The only significant changes are the way we have changed some of the location of individual classes within the schedule. A year ago, I started looking at it from a different perspective, that there were things that I would like to have prepped earlier in the program, to include the first aid, CPR training, some of the smaller block instructions, so that as we move forward into scenario-based training, officers would already have some of that under their belts, so they could immediately speak to whether it's fair and impartial, legitimacy, some of the other portions of that while they're getting started with their very first scenarios. I thought that was a very important thing to do. None of the curriculum hours have changed, with the exception of the active shooter block. We removed that from patrol procedures. We're still working in conjunction with TSU for Patrol Pro, but saving the active shooter block until the very end of the program, actually after graduation. That gives them the alert certification following training. I thought it was important that all officers be able to have that training following graduation, in accordance with their own respective agencies, if that's something they want them to have. moving forward, to answer part of your second question, the iAtlas and how that's going to affect or change the look of training right now. My hope is that it's going to continue to offer us the ability to do more hands-on immediately after the instruction in the classroom. I think the most recent models that I'm seeing from other academies across the nation are a move towards talk about it, teach it, and then go out and do it as quickly as possible, as opposed to have a series of classroom lectures and then ask the student to following that 3 to 4 week period, try to implement that in scenario-based training. I'd like to see us move to a model where we can do that perhaps in the same day that the discussions actually occurred.
On that, Ken, will there be an increase in going forward? Do you think it's important to see an increase? Because you know some of my background working with you around firearms fundamentals, whether that be scenario based, which I'm all behind, or just more range time to get officers who are going to be going on the field for the first time really well suited in the most dangerous aspect of their job. And that is also not to themselves, but also to the public at times. So I'm just trying to get an idea of what the future brings as far as more range time and firearm fundamental time.
I think part of what we're looking at, and not having seen a final product from iAtlas yet, I'm not sure what their recommendation will be. So I'm anxious to see and get a better sense of what that will look like. In terms of additional firearms time, I think part of my hope is that we'll be able to spread out week 9. So for the members of the council that may or may not be aware, during week 9 of training for the full-time basic, we currently spend the entire week either on the range doing firearms or out in the back doing driving training. I would like to spread that out. I think that week is fantastic, and it's my favorite week of the year. That said, I think the repetition and the muscle memory and the practical application needs to be spread out throughout the duration of the 17 weeks as opposed to just that single week. We are currently able to follow up from that week during week 13 with a refresher day where we get them back out into a car or we get them back out on the range to continue to hone those skills. In my mind, the training model should look like smaller bits of that apple throughout the duration of the course as opposed to just in 1 week. We'll see what the iAtlas comes up with their final recommendations from both the JTA and their curriculum review. But that's my hope moving forward, is that more and more of that training is going to be spread out through the duration of that 17 weeks as opposed to just in single months.
Really appreciate all that, Ken, and a lot of respect for the amount of work you do there. Thank you.
Yeah, thank you, sir.
Other questions or comments about Ken's presentation? Mark Anderson.
I think Chief Frank's before me, Chair.
Go ahead, Mark.
Ken, thank you. I'm looking at the document titled Curriculum Summary 1, the Excel document. Is that representative of the entire level 3 program, including post-basic?
So at the very bottom of that, yes, it is. But at the very bottom of that, you'll see CEW and alert active shooter response. That is now post-basic.
So what's in red is, well, between the red lines is post-basic?
Yeah, at the very bottom, sir, yes. So
Uh,
total hours for basic training should be 832.5, and then 16 hours of CEW and 16 hours of alert training.
So the question I raised before COVID, and I know that was many moons ago, there are several things that were part of the post-basic program. I'll include DUI, DRE enforcement. I think FEMA, I'm not positive on that. First aid, I believe, was part of that. And the reason I raised it is that I'm going to be sending 2 people, hopefully, to the February class. And they've already received those training hours. To pay them for DUI enforcement is a week of training pay that I could be applying to other skill sets. is there a consideration for why we're including training that is often obtained through level 2 training in the standard level 3 program?
Yes, sir. So part of the reasoning behind particularly the DUI was that with the A-ride and the requirement for all officers prior to our most recent iteration, it made sense at that point to include the DUI school actually in the 16-week, now 17-week school, so that all officers coming out would be eligible to complete that A-ride training within the following 2 years.
And is it safe to say that that change has been effectuated and A-ride is no longer required?
The change for DUI to be incorporated within level 3?
No, that my understanding, you just said that A-ride was required for all level 3. That was a statutory requirement. I believe that that was rescinded.
My understanding is that it has been rescinded.
Does the same logic stand to hold that DUI is necessary as part of the level 3 basic as opposed to pushing that to post basic?
And that's one of the things that we're looking at, is to go back from the 17-week that we're currently at to the 16-week. I think part of the desire right now is to get a better sense from IATLIST what direction they're going to move forward with that from the national practices, and make sure that we're going forward with that. And because we haven't actually had that vote on A-ride, I think there's concern about pulling that out just yet.
Okay, and my understanding also through COVID, some classes that were part of post basic were included as part of the full-time basic or level 3 basic because of the need to accomplish the hours, and they were classes that could be delivered through Zoom.
So during COVID, we did offer some of those through Zoom. We were very fortunate that we had a bunch of instructors that were really great about turning around quickly and trying to develop presentations that they could do via Zoom or doing Teams meetings. Correct. Now that we have the ability to bring everybody back, we're trying to get those all back in person again.
Great. So, Chair, I just want to make a broad commentary or a request of the Academy staff. In the timing, it makes sense because I know there's a lot going on, that an evaluation of the basic versus the post-basic courses be considered. I don't think there's probably time for that before the February class, and I'm probably going to have to eat the cost on my 2 people, but that's okay, because I understand the reasoning why, I support the reasoning why it happened, but also knowing that we have level 2 officers going to level 3 training who are receiving duplicative training from what they've already received. It doesn't necessarily enhance or enforce any additional skills, and there's opportunities for agencies to find alternative uses for those funds for increased training to other personnel or to those individuals. So I guess to say succinctly, my request is that we evaluate courses that could be included in post-basic, especially when they're already trained. Thank you.
Thank you. Chief Frank, do you have a hand up? I'm not seeing it.
I was prepared to move it forward to a vote for acceptance of the curriculum as presented, but I was not aware there was still discussion, so I will stand by until that point.
Any further discussion on the issue before we do ask for a motion to approve the request? All right, Chief, you've got the floor.
I'd like to move forward to a vote for the acceptance of the curriculum as presented.
Second.
It's moved and seconded to approve the request to approve the curriculum as presented by Ken Hawkins. Any discussion on the motion? Hearing none, all those in favor, please say aye or raise a hand.
Aye.
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 Any opposed to approving what's requested? Consider it approved. Thank you.
Thanks, sir.
Next issue is a matter that Senate Government Operations Committee has asked of the council. I got a call last week from the chair, and the excuse me, the Senate Government Operations Committee is a constitutional amendment, and just smarter lawyers on the call than I can make it clear when I'm wrong, but the constitutional amendment basically requires 2 votes in 2 separate biennia of the legislature. So this being year 2 of this session, if it passes this session during one of the 2 years, and the next session it will likewise need to be approved, and then it is brought for a statewide vote. So it's not a quick process to amend the state constitution, but the committee is hoping to move this forward, or at least have the legislature vote on this, whether to keep the proposal alive. And it would amend the state constitution to allow the General Assembly to establish by law qualifications for individuals to be elected to certain county offices, and it would also abolish the office of high bailiff. And this is really enabling legislation that would allow the legislature, if it ultimately becomes part of the Constitution, to establish by law qualifications for the election to and holding of office and removal from such office for failure to meet or maintain the required qualifications. First of all, for the assistant judges, or so-called side judges in each county. A similar provision for the sheriff of each county, again allowing the establishment by the legislature of qualifications for the election to and holding of the office of sheriff, and procedures for removal from office for failure to meet or maintain the required qualifications. Similarly, for the position of state's attorney of the individual counties, essentially identical language. And then procedures for removal from office of probate judges for failure to meet or maintain required qualifications. So this affects no change in current law, but would allow the legislature to move forward to another year of the legislature considering this proposal, if they approve this proposal this year, and then ultimately a vote of the electorate in Vermont. And it would be only at that point that the legislature, if that process is followed and there's approval of these changes, would then the legislature have the authority to create these qualifications and such, and procedures for removal. I haven't been over in the legislature on this, but they've asked me to offer testimony on the sentiments of the council on this issue. They've heard from a number of stakeholders already. I don't know chapter and verse. They've had a number of speakers who have spoken in favor of the proposal, some that have declined to take a position, and then I think the sheriffs have expressed opposition to the proposal. I'm sure I'll be corrected if I'm wrong. And my sense is that the part of what this is all about is what the legislature has been considering involving the Franklin County State's Attorney, who was the subject of an impeachment proceeding, but resigned before an impeachment vote was taken. And similarly, the legislature is still considering the possible impeachment of the Franklin County Sheriff, an issue that very much has fallen within the jurisdiction of this council. And as you will recall, in November, we had 2 contested hearings involving Sheriff Grismore from Franklin County, and those able to voted to that he had violated the state's use of force policy, and then with 1 nay vote, the other 15 members of the council who voted on the issue of response to the violation of the use of force policy, 15-1 vote to permanently revoke Sheriff Grismore's certification. But because the sheriff is a constitutional officer, and there's nothing in the Constitution or statute that says that a sheriff must have certification, our action impacts Sheriff Grismore's ability to take law enforcement actions, but it certainly does not remove him from the role or office of sheriff. That would need to be done through impeachment. And my guess is the legislature finds impeachment to be a lengthy and rather inefficient process, takes a study and then action by the House, and then essentially, just like federally, a trial before the Senate. So the issue for us today is quite simple. What is the sense of the council on this matter? The Senate committee was going to take a vote on this issue last Friday, but when they were in touch with me and asked me to speak on behalf of the council on the issue, we hadn't put this matter on the agenda of the council. So I would have only been comfortable speaking for whatever my personal feelings are on the proposal. And really, I think they more wanted to hear what the full, and as they should, what the full council thinks on the issue. So that's the matter before us for discussion, and I can ask for a motion and a second on whether to be supportive of this constitutional amendment, and then people can speak their mind before we take the vote. So is there a motion on the issue of the legislature of the Vermont Constitution being amended to give the legislature authority to set certain prerequisites for performing the offices I mentioned, removal from such offices, and the like? So asking for that motion. Sheriff Anderson.
Mr. Chair, my motion would not be those exact words, but.
Well, you make the motion. I wasn't making the motion, Mark.
Mr. Chair, I make a motion that the council take no position on Proposition 1.
Is there a second to Chair Mark Anderson's motion?
I second that, Chair Kelly Price.
All right. And now a discussion, and I think that a suggested revision to that motion would be in order, which we would take up if and when that such a revision proposal is made. So now looking for discussion on the motion for the council to take no position on the issue. I usually talk enough.
Chair, I think
Okay.
Erin Jacobson has her hand up, Chair.
Oh, I'm sorry, I can't see in this framework. I only see Mark Anderson's hand up, so no slate to Aaron. Aaron, the floor is yours.
Thank you. I couldn't find the hand raising button quickly enough. I would say that the council should not take a position as to side judges, or I don't even know what the other offices were, and I haven't digested the proposal. But as to sheriffs, I think we can take a position. So I just wanted to modify or request that Mark clarify his motion a little bit.
Or
you
you're
saying-
suggesting that Mark's motion be amended to just be limited to taking no position on sheriffs.
No. I'm
Oh.
saying we could take no position on some of the other offices
Oh,
because
I'm sorry.
I'm not
sorry.
sure how that's really in our jurisdiction or our expertise as the council, but as to
I understand.
sheriffs, yeah.
What you're saying is that we should, you would take the position that we take no position as to all positions but sheriff.
Yes.
Boy, that's as
Yeah,
clear as,
wow.
that's as clear as this is probably my last meeting as chair.
Or I could make an alternative motion, but I don't know about Robert's rules, if this is an appropriate time to do that.
Mark, would you take Aaron's suggestion as a friendly amendment and limit your motion to sheriffs?
I'm afraid I cannot do that, Mr. Chair, but I would like to speak to my motion if I may.
Mark,
right.
before you do that, can I just, a quick question for clarity? Are you speaking for the sheriffs?
I am.
Okay. And the council
I don't speak for the council.
as a council member?
I am the sheriff's appointee to the council, so yes.
Okay. Thank you. I'm sorry. I don't know where my manners went.
So Mark has chosen not to accept Aaron's suggested amendment as a friendly amendment. So Mark's motion that the council may take no position on any of the offices that I mentioned is the matter before us for discussion. What other council member or members wish to be heard on this issue? Chief Frank.
I think it would be valuable for me to hear a little more of the reasoning or explanation so that we can, as a council, better understand the lack of support. Maybe I just missed it. It's not clear necessarily as to the reasoning behind that. And I think it would be helpful and educational, at least for me. I don't know if others have an interest.
I have an interest.
I do too. Well, Mark had offered to explain his position and I interrupted him.
Do I have the floor, Mr. Chair?
You do.
So hello, everyone. Just for the basis of explanation with the legislature, my understanding, and anyone who deals with legislative testimony, feel free to correct me or help me understand better. There's generally three positions. One is we do not support. One is we do support. And then a third being we don't have a dog in the fight, but we may offer comments. So I am suggesting the council take the third position. The Criminal Justice Council, as everyone's aware, has authority over certification as well as over professional regulation. Sheriffs have, as one of their duties, law enforcement responsibilities and credentials. We have already exercised our role and abilities with that and have removed, in the case of the explanation by Chair Sorrell, we've exercised the removal of a sheriff certification for the purposes of Act 56. outside of the purview of the council are numerous other duties that the sheriff is responsible for, which are not law enforcement duties. And so to the extent that the council oversees, the mission of the council is to oversee law enforcement broadly. I'm not going to quote the mission statement, but that's basically our charge. The concern I have is that the council will be pulled into a dialogue, into discussion with regards to things that the council generally has no purview of. Last session, the council was asked to oversee evaluation of sheriff's compensation, which I believe the paraphrase when I had a discussion with the chair was, why were they asking us to do that? And this has become an incredibly political discussion. Sheriffs in Vermont, and specifically the Vermont Sheriff's Association, do support transparency. We do support accountability. In the circumstance of Sheriff Grismore, the Sheriff's Association called for him to resign. The governor has called for the sheriff to resign. There are constitutional remedies that can cause for the removal of the sheriff. There are also political remedies for the removal of the sheriff. Some of those have been exhausted, some of those have not been exhausted, some of that process continues. What Proposition 1 does, however, is it says that we're going to look at county elected offices to decide what is or is inappropriate for the voters. It ignores state offices where there have also been documented issues. One example being the governor's office, the former governor's office with the EB5 scandal. We've talked about issues with whether the attorney general needs to be, attorney general, the auditor needs to have any credential whatsoever. They do not. The Secretary of State or other state offices have no qualifications or credentials other than they needed to be a resident when they were elected. And so it starts to set up this this interesting system in which at the whim of the legislature, they could cause for the elimination of access to an elected office purely on political foundation. They could cause a removal of a person on political foundation. And we are seeing that in other parts of the country, including in Florida, where the governor of Florida was causing for the removal of state's attorneys because they were opposing abortion policies that the governor's administration supported. I can go way into the weeds on this, not my point, but there is a lot of political pieces to this. Speaking for the Sheriff's Association, if the goal were to make impeachment easier, it would probably make sense to go work on the impeachment portions. I suspect, my personal opinion, is that making impeachment easier is also not necessarily acceptable because it makes other offices vulnerable. And so I feel like this disenfranchises voters. It sets up a circumstance as unique and even potentially unconstitutional if viewed in our current structure of the Constitution.
Let me explain. I think there are legitimate issues where the legislature, rightfully, given the fact that the council was created by the legislature, values our voices on certain law enforcement issues. I was of the view when the issue came up of how much sheriffs should be paid, thinking that that really is not in the wheelhouse, if you will, in my view, of the council. But, for example, whether a sheriff, as opposed to every other law enforcement officer, state or local law enforcement officer in the state, ought to have a certification in order to be able to do his or her job, that's the kind of thing that strikes me as an issue that the council, with its various voices, could legitimately be called upon to to speak. So fast forward, if you will, to whatever the legislature does with this proposal, and assuming that the legislature approves it, as drafted or as amended, does it again next year or the year after, and then goes to a full vote of the electorate in Vermont, and it's approved, my guess is the council would be called upon not to speak to side judges and probate judges and such, but the council would potentially be legitimately called to ask for our opinion on what the actions or inactions, baseline qualifications and such of sheriffs should be. And I would see that as legitimately within our purview to ask us. No guarantee we would have anything approaching consensus, given the makeup of the council, but I think the council was created to have any number of voices, which might well be contrary to each other, and discussing law enforcement matters, and that we might get further into the weeds than maybe even the legislature is in a position to get. So that's why I didn't think that we should be speaking as a council on whether sheriffs should be paid X or 2.5X. Whether a sheriff ought to have law enforcement certification or to be sheriff is a matter that I would say is certainly legitimate query or matter for consideration by the council, and where the council's position certainly wouldn't be dispositive with the legislature, but would be something that legitimately the legislature would want to take into account. So I'm in agreement with the thought that we don't have much to offer about side judges and arguably state's attorneys and the elimination of high bailiff. I don't think that those things are in our purview, but I think the inclusion of sheriffs is something legitimately asked of the council if we wish to take a stance.
Mr. Chair, just to clarify, I want to be clear. I'm not saying take away the council's voice. I think with no position, we can offer a voice that may even include dissension. So
let me interrupt you, Mark. I was criticized for not taking a vote on the issue of our having more authority on a first category B offense. And the suggestion was I didn't take a vote, so it's not real, and that I shouldn't be speaking on behalf of the council. So choosing to disagree with you, do me wrong once, and that's somebody's mistake. Do me wrong twice, it's mine. I want the council to speak to this issue.
Just to clarify, Mr. Chair, I don't think I ever did you wrong once, but I just—
No, you didn't. It wasn't you. Trust me. So where do we stand? Any other council members wish to speak on the issue right now of whether Mark Anderson's motion that has a second, that we take, and I don't want to be wrong in phrasing this, we take no position on the issue of the proposed constitutional amendment?
I think what I'm understanding Mark to be saying is that if we took the position of not taking a position, that is our answer. So it doesn't necessarily put the council or yourself, Chair, in a bad position because you're giving an answer that the council has accepted or moved forward. Is that what I'm understanding correctly?
I'm not sure I understood what you're trying to say there.
I'm referencing, I guess, your concern, and forgive me if I'm misunderstanding. Referencing your concern around what had happened before and how that kind of transpired. If it became a position, and our position was that we were not going to give any position on this topic moving forward, then if you, as the chair, were to make that announcement to whoever bodies are looking for our response, you've been essentially given the blessing of the council, the entire council, to make that statement that we are not taking a position.
I understand. I think if Mark's motion carries by a majority vote of the council members voting today, then this afternoon, when I appear before the Senate Gov Ops Committee, I would say that is the majority sentiment of the council, that we take as a council no position on the constitutional amendment, particularly as it relates to sheriffs, which we see as within our jurisdiction. Aaron, you have your hand up.
I cannot support Sheriff Anderson's motion. I would vote against it. I do think the council should take a position. I personally, not speaking for the Attorney General because I haven't been able to take this to her for her thoughts, but I personally think that the legislature should be able to create qualifications for sheriffs, much like they do for other law enforcement officers, which the council then is charged with enforcing. So, I appreciate Mark's comparison, comparing sheriffs to, I don't know what you said, auditor of accounts or something. But I think that's kind of a false comparison, and it's apples and oranges somewhat. And the comparison should really be between sheriffs and other law enforcement officers. So I think the council should take a position. I can't tell you what the Attorney General's position would be today, so that does not help you, Bill, since the hearing is at 1 o'clock. But I would not be supporting Mark's motion.
Others on the council who wish to speak for or against the motion that's on the table, being that the council takes no position on the constitutional amendment. Jim Whitcomb. I think you're muted, Jim.
In discussion as proxy with the commissioner before this meeting, I was of the position that I was going to abstain from a vote of review or inclusion of this amendment discussion. I will continue to interpret that as that the commissioner does not want to weigh in her position on the council on this discussion, and that it is it's her position that it's not that the council should not have a position on this.
So are you abstaining or voting no?
Well, I'm going to interpret that abstaining as
or voting yes,
commissioner,
I guess, on this motion. I'm sorry. Don't mean to be confusing.
That there should be no, that I would vote yes to this proposal from the sheriff.
So DPS is in favor of the standing motion.
Correct.
Thank you. Other.
Bill, I just like to ask a clarifying question, and I appreciate the discussion, and I do recall what happened last year. So just if there is no position from the council, what do you say? How do you manage that, particularly in light of last year and the no vote? And Mark, if I recall, I think you too, like you were one that was concerned that your position wasn't fully represented through a vote last year. And I'm just kind of, I think I'm just I'm a little bit confused about the line between one's lane and one's opportunity to be a member of a council and represent the point, the concept, and the mission of the council. And I want to say that that's just my position and or my opinion. And Bill, I really do kind of want to ask you, like, how do you manage that? I think it would be useful for the rest of the council members to be learning and hearing the impact of this.
Well, I'm assuming if the standing motion passes, then I am required to say that the council by a majority vote has declined to the legislative request that we take a stance and articulate our stance to the legislature on the proposed amendment. That would not preclude me from, if they ask, saying, well, what's your personal opinion? But I certainly would have no authority to speak on behalf of the council, because the council, the majority of those voting, elected to take no stance.
May I offer maybe a competing thought or complementing thought, Chair?
Sure.
Just very quickly.
Although there are other hands up, which we'll get to here.
To answer Heather's question, though, I think having no position doesn't preclude the opportunity for the discussion. Sheriffs do have a law enforcement job, which the council does have a purview into, and I don't disagree with Aaron in saying that, disagree with the chair in saying that. And I think that that is an opportunity to say, yes, we do have a purview over sheriff certifications, and that currently exists. Council has no authority over civil process, has no authority over a lot of the work we do. In fact, law enforcement is a minority responsibility of most sheriffs.
That's really?
Yeah.
Then why would it?
That depends on the county, really. There are sheriffs who are primarily law enforcement officers and sheriffs who are primarily in the business of sheriffing. Chris Lewis.
Yeah, thank you. I'm just looking at the proposed language for the constitutional amendment, and for the relevant section regarding the sheriffs, it says right now, sheriffs shall be elected by the voters of their respective districts as established by law. Their term shall be 4 years and shall commence on the first day of February next after their elections, with the change being the General Assembly may establish by law qualifications for the election to and holding of such office. And it speaks nothing to certification. It speaks to qualifications. From my perspective, and having seen the legislature work, having been a member, that's, I think, from my perspective and my perspective alone, a little bit too broad when this council has shown over the last 6 months, especially, that we deal with certifications. And I'm not comfortable supporting the language, as I feel it's too broad, that the General Assembly may establish by law qualifications. I personally don't know where they could go with that. I'll say I don't trust 180 people to align themselves with what I think qualifications are. And I don't expect, the other 23 members of this council to have my same opinion of the legislature. But that's where I'm coming from, is giving them the authority to establish qualifications for the office of sheriff. It just doesn't feel right to me. And So with this language, I would say I do not support the constitutional amendment as currently written, so I would have to support Sheriff Anderson's motion.
All right, Jim Wickham, you have your hand up again, or?
No, I'm sorry, I just didn't lower.
Okay. Other council members who wish to be heard on this issue, I'm assuming we still have a quorum.
Chair, Chief Frank, representing the Vermont Association of Chiefs of Police. I think there's a win-win in this, and I think possibly it's perhaps not necessarily speaking to or supporting it as written, but speaking to the concept. So for example, qualifications consistent with those established by the VCJC for law enforcement certification. So that's very specific. As it's written now, it just says may establish by law qualifications, but it's not clear what those qualifications are. They're not vetted. They could change and come as and go as a whim, as I think Sheriff Anderson was referencing, for example, the situation in Florida. I think we could support the concept of, yes, there should be some sort of level of qualification that says you can or you may or may not continue to hold this job, office, or position, but somehow having a caveat that says with those established by VCJC for law enforcement certification. That makes it fair, whether you're a sheriff or a municipal officer, same rules, same expectations, same laws apply. So I think we could have a win-win here, which isn't necessarily that we're saying yes or no to the bill as it's written or to the amendment or proposal as it's written, but we are saying, yes, conceptually, we agree that there should be some level of accountability. I'm not sure how that fits into our current discussion.
I would think that if this proposal passes the legislature and passes again the legislature a year or two out, and then by the voters generally in the state, that the council and the members of the council who are serving at that point in time, which would be 2+ years out, would be called upon to take a stance or make recommendations on the qualifications and job performance standards of sheriffs, not the other positions. So I think that we would be consulted at this juncture, asking for the legislature to amend the proposal to bring the council into the constitutional amendment. If I'm understanding what you're suggesting, Chief Frank, that strikes me as unwieldy.
I guess what I was trying to say is we could state that as it's written, perhaps there's not support or approval. However, we support it in concept. Here's our area of concern. Just trying to be able to get some feedback for modification for them as they move forward.
Well, if this motion passes, I'm not sure that I would be comfortable saying that the council has flexibility here or whatever. Or the council is saying we take no stance. And I'm not sure that I would be comfortable saying we take no stance, but, because then the question would be, well, did you take a vote on what would be in the but? And the answer to that would be no. Others on the council who wish to be heard on this, and again, my question, do we still have a quorum? I know Susanna had to get off. I think Karen Tronsgaard Scott had to get off.
We still have a quorum. We're at 14.
All right, good, thank you.
You're welcome.
Other members of the council who wish to speak on the issue at hand?
Chair, if I may again.
All right.
Kelly Price again. I guess one thing that I wanted to bring back into the forefront of what Sheriff Anderson stated earlier, one of the things that's really sticking with me, and please anyone chime in and help me feel better about this, but it really comes down to the voting public aspect of this. It really bothers me to think that a body may be able to circumvent, if you will, the voting public of the constituents of that particular sheriff's office. That just bothers me. It would sort of be like the concept of the legislature putting forward something that would give them the ability to remove the governor. It just seems like it disenfranchises the people who put that person in office. And if they want them removed, there is a process to do that. And again, that's the voting public that put them there in the first place. I just wanted to put that out there.
There's the ability to remove by impeachment the governor and other statewides and county officials. That's the mechanism under current law. And I think the legislature's finding from as I mentioned earlier, the process for the Franklin County State's Attorney and Sheriff is finding the impeachment process to be burdensome.
Well, as we have seen both in the federal government and state and local governments, that unfortunately, and I don't think we would disagree with this, that the impeachment process in and of itself is typically a very political process. And that's where the rub comes in. It's not just as straightforward as they have the ability to impeach. Yes, I get that, but it's no longer used it appears that it's no longer used the way it was intended.
Your point is that we shouldn't change the law and leave the impeachment process in place and not tweak it with the legislature muddying the waters, if you will, by creating other procedures to remove certain officers.
Well, Chair, I guess in a nutshell, I just wanted to say that I just don't think that we need to wade into these waters, to be honest. I mean, to make it as simple as possible I don't think it's where we should go as council.
That's a discussion that maybe we don't need to have right now, but if and when we have a retreat, my guess is there would be differing views to your own articulated should such a discussion take place. Any other council members who wish to speak on the pending motion before we take a roll call vote on the pending motion? Hearing none, Lindsay, would you call the roll, please?
Yes. Kelly Price?
Sorry about that. My mute button, apologize.
No worries.
No, I keep my current position, which is to support Anderson's position.
Okay. Cassie Birdie Shaw?
I'd like to abstain.
Chris Loris?
Yes.
Aaron Jacobson?
Sorry, point of clarification. What are we voting on? I thought we were voting on Mark's motion to not weigh in.
To take no position.
So no. I think we should take a position, in other words.
Glenn Boyd?
Yes.
Jim Whitcomb?
Yes.
Lori Vatican?
No.
Mark Anderson?
Yes.
Mike O'Neill?
Yes.
Sadie Donovan?
No.
Scott LaValle?
Yes.
Chief Frank?
Yes.
Trevor Whipple?
Yes.
Kareem Chapman?
Yes.
That's 9 yeses, 1 abstention, 4 noes.
All right, the motion passes, and I will make clear to the Senate Government Operations Committee today that the council by majority vote does not wish to take a stand on the constitutional amendment. All right, Executive Director updates.
Mr. Chair, real quick question on that. It's more of a point of order, in spite of the fact that I voted yes. And I apologize that it may not be clear in our rules. I don't even know if it's clear in Robert's rules. I have to check that. Are our motions, given our quorum, given the number of people in the body, is it number of individuals present and voting, or is it majority of the body? I've seen it both ways in rules for other bodies, where if I know there is, I think it was Vermont State Supreme Court case law regarding select boards and the equivalent, city councils, that votes are not considered legal, or whether yes or no, unless it's a majority of the body. I don't know if that applies to us or if we are present and voting.
I can defer to Kim McManus, but my view is that it's a majority. If we have a quorum, it's a majority of the quorum that determines
Thank you.
the council's stance. For those who aren't present or abstain or whatever, their voice is not heard.
Okay, thanks.
Bill, that is correct. Your summary.
Thank you. All right, let's move on to the executive director updates. And then we do have two stipulated settlements on professional misconduct certification issues, I believe. Heather, the floor is yours.
Thank you very much. I am towards the end, so I'm happy to report that much of my report was already clarified. Thank you, Bill, for your question to Ken, because that was a nice transition into what we can expect out of the job task analysis. And Ken did a great job. One, keeping it brief because there are a lot of topics, but two, also giving, I think, everyone a sense of how much there is to cover and how content fits together. I wouldn't have changed anything about your report out, Ken, if you're still on. I just wanted to add that for purposes of your question, Bill, afterwards, it's on the agenda for the next council meeting for us to walk through the various levels of certification so that we can all get comfortable with what that looks like and what the implications are of that. And as it relates to this job task analysis and the larger project with IATALYST. So one thing to keep in mind, which is in relation to your request, Mark, for us to take a look at the DUI training in level 3 and consider it for post-basic. And just for reference, we're going to be doing that pretty much with everything. The question being, what makes sense to be in basic training, and what do you need to certify or graduate from basic training as opposed to continuing what you need, and how much of our decisions over time have been made to accommodate operational needs, and how does that fit with evidence-based training. And so in a nutshell, I think we'll probably take a look at it, but I don't know if it's smart to make any big changes between now and when the work starts. And I want to back up and remind the council that that this, as Chair Sorrell said, this work is in many phases.
And we are in the very, very, very beginning formally, meaning we have a new contract to do the job task analysis, and that took some time with a request for proposal and then negotiating a contract. And so the second and third part of the project, that has just barely been posted and bid on. And we are just beginning the contract negotiations. And so I'm reminding the council of this and anyone else interested that we haven't gotten out in front of any big changes yet. We're in the very beginning of taking a look at where we are at. And in terms of all the discussions today, I think it couldn't possibly be more timely, whether it has to do with fair and impartial policing or certification for leadership positions, or where we stand as council members or as members of the profession contributing to certification and decertification. It makes that point even clearer, at least to me, that we have to start where we are and take a look at what we do. And the we in this case is all of law enforcement. And so you are going to, you're going to see another announcement about this job task analysis going. I think it's live now, but it hasn't been announced yet, and it will be this afternoon to all of law enforcement to contribute and participate in this survey. And these questions are designed to assess what the job is. And that's really, in a nutshell, this is the opinion of law enforcement as to the job tasks, job description, and duties of law enforcement. The report that IADList will provide back to the council will be less about recommendations and more about interpreting the data. And the leadership in law enforcement will be weighing in on how this impacts the direction of recommendations to what certification should look like and what job description should look like. That, I know for most of you, you've heard this already, but again, I have to say, in terms of the relevance of today's discussion, a lot of things that seem complicated right now might become less complicated as we move forward in determining what people need for training in order to start their job and what they're going to need on an ongoing basis. And I have received a lot of that feedback in terms of some of that confusion in the last few weeks. And so one change that we've made with regards to communication is that my updates will be probably getting a little bit more in the weeds, but that will be in writing to the council along with any other attachments. So if there are things that normally I wouldn't consider to be things that I would use council time to report out on, you will be able to read on a regular basis, and it might be overkill for a little while. You may not want to know if the dishwasher is broken or not, but I think if I'm understanding feedback from lots of stakeholders is that there's a little too much mystery, and I want to be sensitive to that and make sure that folks are not thinking that things are happening without being informed. But really, I have been quite optimistic about the direction that the Academy is going in, and incredibly impressed with Academy staff who have kept the doors open. And I always appreciate the phrase drinking from a water hose, because that's exactly what they've been doing. And I would like to go back to the, just a couple of years having thought about it, certainly with regards to Chris, you stepping down, and we really appreciate all that you've done and your commitment to the council, and being part of the process for as long as you were, you've been able to see the evolution. And there were references this morning, for example, like during COVID. So if you go back a couple of years, we were really just trying to stay open and do as much COVID mitigation as we possibly could. And I am pretty pleased to say at this point, we are now at a place where we have full leadership capacity, and that's something that I'm incredibly proud of for our directors who have pulled together and tried to learn each other's jobs while they develop their own. I think you mostly know that most of our staff are pretty new, and they've been all have been incredibly cooperative and enthusiastic about jumping in and helping us figure out what each role is. And again, that's going to matter moving forward, because now that we have some capacity, we'd like to get much more specific about a clarity of roles with each position, and also clear about where information comes from, and that can funnel more easily to me, and folks will hear from me more often, which I look forward to. And so that was sort of a long way of capturing this, a report out that I was going to give that much was covered this morning. There's one other item that I don't want to forget, and that's that there was a discussion at Chiefs and Sheriffs meeting, which I was very happy to be invited to and attended. It was incredibly telling to me about where I was thinking to give an overview and what people and what leaders really needed to hear about. And so I am going to get, that's another area where I'll get a little bit more in the weeds for a little while to understand our certification process and how we schedule. But there is a recertification process for firearms instructors. That's not the initial certification, but a recertification. And that evidently happens once a year. And we were not able to deliver on that recertification. And so I have approved giving a waiver so that all instructors can have a few more months. I believe we start that recert in March, and it goes through until October. And normally I would probably be updating the council and looking for discussion on the fact that I was going to do that. I do have the authority and I did do it, but it's a little backwards. I'm telling you afterwards. And we also posted on the website a little quicker than I was comfortable with, but nonetheless, people have some information. And in the meantime, we are buttoning up the expectations and guidance, which is another area that folks are going to hear from us a lot more than they have, because that work around the audits office is coming together. And the things that had been kind of driving us to pace sharing information was the audit and of course rules, which those won't be a challenge moving forward. So nonetheless, that I did grant that waiver, and that was a time that I learned that we have roughly 100 firearms instructors in the state, that's a whole nother can of worms and a discussion that I'll probably get into at the next meeting when we review some of the various levels. And Bill, I see my phone is like, is anybody texting me? Or are you guys I can't tell if you're telling me to wrap it up or not.
No, it's not due to that.
Okay, don't worry about it. Keep going.
Don't worry
Okay.
about it.
Also, one other thing. I wasn't quite able to jump in this morning at the very beginning, but we have a new member of the council. If she's still on, Lori Vatican, are you on?
Yes, I am.
Welcome. Welcome. I picked an interesting meeting to come to, but they're all very interesting. Lori is from the Department of Mental Health, and this is your first meeting, correct?
Yes, it is. That's correct.
Well, we're very excited to have you. There's lots to do.
Hi, how are you?
I wanted to give you a chance to say
Here it
a couple
comes. They're
things, but
telling us.
again, don't want to put you on the spot.
Gonna get home before.
I'm very impressed with today's proceedings and really the thoughtfulness. I have so much admiration already. I do have a son, my oldest son is a police officer out in Washington. And so I have so much respect for law enforcement. So it's a privilege and an honor. So thank you so much for letting me sit on this council.
We're happy to have you. So, in light of the work that Kim has to do, I am going to keep this report out to those two summaries with, and again, another reminder that there'll be a more detailed presentation about the various levels, which I think will give more context to what the council voted on today with regards to the content. And just ask if there are any questions.
I guess not, but so thank you, Heather. My question is, do we still have a quorum, Lindsay, for our two stipulated agreements?
We do not have a quorum for the stipulated agreements.
All right. Well, then we will put those on the agenda for early on the agenda next month when we meet.
Those will be on the hearing meeting.
Isn't our quorum 13?
For stipulation agreements, we can't include professional regulation members, so it drops our quorum to 11. It would be 14 if we could include them, but we can't. So they're at, the quorum is at 11 for this.
Got it. Thank you.
But we do have a quorum for a motion to adjourn.
So moved.
It's moved that we adjourn today's meeting of the council. Is there a second to that motion?
I will second that one, Mark. So.
It's moved and seconded to adjourn. Any discussion on the motion? Hearing none, we'll say all in favor of adjourning, please say aye or raise a hand.
Aye.
Aye.
Any opposed? All right. Thank you all very much.
Thanks, everybody.